This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Welcome to the Sunday Altar of BARD, and we have a special guest today, Sara Azari. She calls herself white collar criminal defense, but I always have a problem with white collar. I always like to think of it as red, white, and blue collar. And Sara and I have been having some fun on some of the TV shows. I've known her forever. In fact, she officed with us for quite a few years. She's what would you call yourself? I'd say you specialize in federal, wouldn't you?
Now I do, but like you, Mark, when Mark now does like everything civil, which I won't touch. But when for several years when I started, even still, I have cases in state court that are what people call true crime. I don't like the white collar distinction. I think it's very uppity and East Coasty.
That's exactly. I take great offense to it when people say I'm a white.
I think if you're defending somebody who's accused of crime, crime is crime. I think during the Trump presidency, somehow I was given that title, but I would beg to differ. I definitely have had murder trials and a few death penalty cases. I was on the defense team for the Robert Blake case, who was accused of killing his wife and was not guilty. Different case, but again, we've got a family that's been slaughtered and a prosecution that really has been serving this jury with no science and nothing.
You're referring, of course, to Murdaugh,
to Murdaugh. We've got like a platter of nothing burgers and a side of fraud for 5 weeks. That's the issue I've had. And you've been helping me out a lot.
Well, it's astonishing to me how you find a lot of these the presentations, if you will, are almost cheerleaders for the prosecution as opposed to just calling balls and strikes, or at least saying this is bad, this is good, this is helpful. I just can't. It's been kind of my problem with legal commentary for decades, is that they generally, if you've got this former blank prosecutor, that is somehow gives you the bona fides to comment, and
and then the disparagement, or I should say attempted disparagement of a criminal defense lawyer, like somehow we're less than, we got to know more than, we got to do more than. And I always laugh when I hear, former prosecutor, former federal prosecutor. I'm like, so?
Right. And by the way, my favorite is, I don't know how many times it's happened to you, is when some prosecutor has told me as we're about to pick a jury, I've never lost a case. I said, dude, I'm going to give you the phone numbers of guys who've told me that before because you're about to lose. Anyway, Gary, we've got some curated videos by Sara. Give her a shout out. She's the various snippets from the trial this week.
Yeah, Sara sent in a few, and I think we should just start right off the top with one of the ones where I believe its name is Owens is testifying about the trickery that he used. Let's check it out.
There were multiple weapons loaded with that same load, buckshot and birdshot. I mean, was that an investigative tool, or were you just under the misimpression that was the case?
Investigative tool.
So you lied to him.
I'm allowed to use trickery to elicit a response.
I understand. And so you're trying to trick him. Agreed?
I'm allowed to use trickery to elicit a response. Yes.
Okay. And you're allowed to do it, and you did it.
Yes.
But you also testified under oath in front of the state grand jury. You said basically the same thing, that there were 4 shotguns on the Moselle property and they were loaded with buckshot and turkey load.
Yes.
Now, were you mistaken then, or were you trying to trick the state grand jury?
One of my favorite lines is, if it's the U.S. Supreme Court has said, you lie to the detectives, that's a federal felony or under 1001. They lie to you, it's good police work.
Right. And even that has limitations, right, Mark? That Supreme Court ruling about officers being able to get you to say what they want from you. I would never use the word trickery on the stand. That was, I'm hearing the defense's key word all over their closing argument, trickery. And by the way, this was more than trickery. It was fuckery, because it wasn't just him lying to Murdaugh to elicit what he wants, for that supports the narrative, but it was lying to a grand jury that got him indicted. That is what was so outrageous. And that was so brilliant of Jem.
I could not agree more, because you know what they're going to say in closing? They're going to say, the grand jury are citizens just like you, and they hear this case at a much lesser standard. Now they come in here and they lied to the grand jurors just like you. You're the pettit jurors, and they're lying to you as well. Trickery. Yeah, trickery.
I've always said, and I always say, look, you and I have had first of all, 99% of my clients who do speak, I always hope they don't speak, but when they do, they're either eliminating facts, they are lying about facts. That is, lies are everywhere in our cases, but not every lie is material. And even if I give it to the prosecution that this was a material lie, that he was not at the kennel, or, whatever it was, or how he loaded the guns, there's lies are explainable. Not every lie leads to a conviction. Otherwise, everybody would be convicted, right?
Well, and by the way, why is it okay it's bad for the defendant to lie, right, but it's okay for the cops to lie? And
to that point, I think that leads right into our next clip, which is also concerning the grand jury. So let's check this out.
Agent Owen, before you testified before the Collin County grand jury, you prepared an outline of your presentation, did you not?
I did.
And in that outline, you identified essentially a narrative of what you were going to tell the grand jury, correct?
Yes.
And did you follow that narrative?
For the most part, yes.
And in that narrative, didn't you state that an expert found multiple particles of blood spatter on the shoulders and front of Alex's shirt? Isn't that correct?
Yes.
And is that what you told the Collin County grand jury?
Yes.
However, what SLED and this expert out in Oklahoma overlooked is Agent Zapata's confirmatory blood testing, about which she testified earlier in this trial, that out of 74 cuttings from Alex's T-shirt, 0 tested positive for human blood. Y'all completely overlooked the fact that when you did a human tracing test to confirm whether it's blood, it came up negative. And wasn't that overlooked?
I had never seen that report.
Well, when did you see the report?
November of 2022.
After Alec had been indicted and months from trial. Is that right?
Yes.
Isn't that wild? 0 for 74.
Shake my damn fucking head, right? This is like the dog ate my email that had the report attached to it. 5 months. He could have and should have known that the evidence he's presenting that is exculpatory exists, and he didn't do it. I'm not even sure if he's telling the truth. I'm not going to accuse him of lying, but we already know he uses trickery, so we're supposed to believe one part of his testimony and not the rest of his.
By the way, that's a perfect example of what Brady exculpatory material is. That's the definition of it. What is it? You've gone in front of a grand jury. You've told the grand jury that there is blood spatter. So you've given them that impression. Mind you, it's a probable cause proceeding. I get it. But you then don't follow up. You wait until November. When did they start picking a jury in this case?
He was indicted in the summer of 2022. So November is already 5 months after his indictment. I don't know the exact date, but it's way later. They're getting ready to go to trial. Remember, Mark, they've been the defense pushed for a speedy trial here because of the terrible state of the prosecution's case, right? They didn't want to wait longer. They wanted to go in December, then it went to beginning of January, then it got, pushed back a little bit. But he knew. And that is what is so outrageous about this, is that I've always said the blood spatter, to the extent that it even existed before the destruction of that T-shirt, was the prosecution's best evidence. It was science. They destroyed science. That's why they don't have science. And to lie to the grand jury, I know it's a probable cause hearing. But that's a hell of a lot of probable cause right there that he lied about, right?
I couldn't agree more. Gary, where does that take us? Segue to where?
That takes us to some testimony about the kennels and whether or not Alex has changed his story on that and other timelines throughout the course of the night. So let's check.
Yeah, if you're following this case on Twitter, this clearly is what the prosecution Twitter supporters are basing everything on. I mean, they're invested in this like you wouldn't believe.
Yep.
And I will make a comment afterwards to see where Sarah agrees.
And did your investigation reveal inconsistencies regarding what Mr. Murdaugh had told you?
Yes, I did.
And was that significant to you in your investigation?
It was, because it wasn't one inconsistency. It was several inconsistencies over a period of time that were repeated.
Between June 7th, 2021 and August 11th, 2021, this interview, how many times did he call you asking about the investigation?
We spoke approximately 5 or 6 times.
What were the inconsistencies that you stood out in your mind?
The times, for one, from the first interview where he went to his mother's. The first interview in June, he stated that it was at his mother's for approximately. First off, he stated for a little while. And then the second interview on June the 10th, it changed to about 25 or 30 minutes. And then the third interview, it was 45 minutes to an hour.
Was he ever inconsistent about whether or not he went down to the kennel after supper that last?
Yes.
Did he ever say he did go down there after dinner?
He never told me he went down there after dinner.
Never told you that.
He told me he took a nap and then he was at the house after dinner. He knew Maggie went to the kennels. At first, he wasn't sure where Paul went, but then he realized that Paul must have gone to the kennels because that's where he found him. But then he stayed at the house, took a nap.
So there, Sarah, is, I think, probably the strongest piece of prosecution evidence, which, by the way, once again comes out of the mouth of the accused, which is why we often say, shut the fuck up.
He's not the kind of guy to shut the fuck up, and which is why I think he's pushing to testify. But look, the same investigating officer, Owens, also said that the most common inconsistency with suspects is time. They cannot get time right. And when you look at, you take this out of context, yeah, it looks really bad. But when you put it in the context of Alex Murdaugh estimating time, for example, in his video interview when he was in detox in September, the guy's not good with time. I mean, even about things that don't relate to the murder. And by the way, if you calculate based on the car data, how long it took him to go to his mother's and back, and then you add to that the 20 minutes that, again, the car data supports, this is all the state's evidence, you come up to about 55 minutes or so, which is consistent with about 45 minutes to an hour. The questions he was asked were not parsed out and very specific. How long did it take you to drive? How long did you actually stay? These were like, how long were you at your mom's? I mean, he calculated including travel time. These are so explainable. I do believe, Mark, I agree with you, that the omission, whether you call it an omission or flat out, lie or denial of being at the kennels, given the kennel video, is really what the prosecution has, and some cell phone data, which you and I have talked about, that it will be blown up very soon by 3 experts this week.
Yeah, I think you're going to find, because I think the GM data both helps and hurts both sides. I think it's equal opportunity.
It's about the jury adopting a certain interpretation of that, and it's about showing them the other interpretation, because we've only had 5 weeks of one side, right?
Right.
So, and that same thing goes with the time of death. I'd be dead if I'd be dead 20 times a day, 5 hours at a time. If you look at my phone activity, I mean, sometimes I leave it somewhere and I forget. So, phone.
Right, I know. And by the way, we'll get to it. Gary, what's the next clip? Because I don't want to step on the last clip that I think you've got.
Yeah. So our last clip here is one of the agents testifying specifically to the timeline, and we'll check it out.
That's it.
He arrives at the scene, gets out. presumably. He goes in the park. And then 20 seconds later, first dials 911. Is that your testimony?
Yep.
So pulling up on the scene, body's in his headlight, presumably knows something's horribly wrong, gets out 20 seconds to the first call to 911. Is that correct?
That's correct.
So he had 20 seconds, and I think there's maybe an implication, or that's not enough time.
Objection is sustained to the comment of counsel.
Is this timer set for 20 seconds?
It is.
Okay. When I say so, would you please press the start button?
Okay.
Now.
I love this guy. Just looking one way, looking the other way. Amazing.
That was 20 seconds. Would you agree?
Per your phone, yes.
Per your phone, as if there's some alternate universe.
I like at the end there, that lawyer was like, "You don't dispute the phone, do you?" No, I don't.
I just per your phone. These cops, they just can't help themselves. Always has got to be a comment.
It was a long fucking time. Listen, Mark, this morning, Twitter was on fire over this issue that, he came upon them. He parks his car. He sees them. He goes over, checks their pulse. There's blood. He calls out. It's like, no, all he says on the 911 is, there's something wrong. There's something bad has happened to them. He doesn't do all those things on the night. He's not done all those things in 20 seconds. And that was a long time. I used a time. I love timers. I think they're very effective because when you hear seconds, you think it's so quick. But when you actually time it on a timer, it's a long fucking time. I had a military trial, a court martial, 10 years ago. My client was a tech sergeant who was accused of rape by another subordinate. And, the theme of the case was she got caught with her pants down because that literally is what happened. She was caught at a party. She was engaged, messing around with my client and said it was rape. Well, she said she was choked really, really bad, where she had marks and everything. She had no marks for something like 40 seconds there. And she just walked out. No, she didn't black out, nothing. So I timed it and it was a bench trial. The judge was like, shake my damn fucking head. We're done. Like this is, so timers are very effective. And that to me, Barber is a great science guy for the defense. He's got all the phone stuff and all that. And I just think he did a very effective job.
Yeah, and I think we're going to hear a lot from him this week. And, sir, we may bring you back later this week, right, Gary?
Absolutely.
I suspect, what's your prediction, Sarah, on how long the defense case will be?
So I think the defense, tomorrow's a holiday, so, we lose a day. But I think the defense will be done at the end of the week if Murdaugh doesn't testify. But from what I'm hearing, he is adamant about testifying. I don't believe he has anything to lose in this case. And I believe that even though it can be argued what needs to be explained, the jury's going to want to hear from him with those explanations. The kennel video being one and lying about it being at the top of that list. And frankly, Mark, wouldn't you tell your client the first thing out of your mouth, if and when you take the stand, is, I did not kill Maggie and Paul, flat out, before you say anything else and explain your lies? I think that's going to be very effective. And I know you and I have been in that attempted disparagement scheme, right? That we were talking about earlier. You and I have been repeatedly called the national lawyers that are not from South Carolina, somehow as though the rules of evidence are checked in at the door of water.
Somehow as if humanity differs in parts of the country, right? People are people.
People are people. And this is great. Your podcast is beyond a reasonable doubt. That's what this is about. You're telling me that fuck South Carolina and Mars, right? You're telling me there's not one person that is going to see through this bullshit? Come on.
Well, I think the reason you hit on the reason I suspect that he will testify, that Murdaugh will, because he has nothing to lose. There's no downside. The fraud counts alone are in some, he's going to.
He strikes out. He strikes out under South Carolina law.
Done. So
yeah, he gets LWOP, Mark. They're seeking LWOP. I mean, it's so draconian. This is where I give it to those men, whoever that says, "Oh, South Carolina," because you got really draconian laws there, including a breach of trust over $2,000, which is almost petty theft for us, is a strike in South Carolina, and the state wants to seek LWOP on him. So he's not going to see the light of day. That's what I'm saying. What's he got to lose?
He really doesn't. He really doesn't. Whether he's whether his lawyers advise him otherwise, you're just not going to. He's not going to listen to them. At the end of the day, it's going to be him.
His right. Right?
It's his right to make the decision. Exactly.
I would love to continue the conversation. There's no better podcast than yours because it's about reasonable doubt. And this case is clouded with doubt. We're not even at the defense really yet. So
thanks, Sarah. Thanks, Gary.
Thanks, Mark. Thanks, Gary.
Thanks, Mark. Thank you guys for joining us. And we'll see you guys next time.
Thank you. Bye-bye.
Bye-bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.